Hey, hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the January 15th, 2025 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman. Sitting to my right, Justice Joseph Ditkoff. To my left, Justice Chauncey Wood. We will be your panel this morning. Usual appeals court rules are in effect, which means each side has 15 minutes to make their presentation. There is no rebuttal in the appeals court. And we will start by calling our first case. Docket 24P151, JB versus DB. I would remind counsel that this case is partially impounded. Please refrain from using any of the parties' names or referencing any other impounded material. Attorney Goodwin.
Thank you very much, Justices. Stephen Goldwyn. So far, so bad.
No, so far so good. The microphone just has to pick you up. Go ahead.
Thank you, members of the appellate court. Stephen Goldwyn, representing the appellant defendant in the underlying action. I'm accompanied by Attorney Graber. I'll start just by saying it's a little difficult to prove a negative, so to some extent I'll call upon my esteemed adversary as well as the court to ask questions as to why the plaintiff had satisfied her burden of proving under 258E that there were the required 3 instances of malicious, willful conduct, particularly directed at the plaintiff, and or that there was another exception, crime such as rape or criminal harassment or otherwise. Before that, however, I would state that I think in looking over this again, the main crux or gravamen of our contention is the second element of a criminal harassment, if that was what the judge was leaning on and or this court, is that the defendant's action was directed towards the victim and the defendant intended that the victim know that each act was directed at them. And I would suggest, without biting off more than I need to chew, it was 180 degrees. This was done, his actions, surreptitiously, clandestinely, and not intended. I don't think there's any proof, never mind proof to the preponderance standard, that his actions were intended to cause fear, instill fear, or was directed by taking those photographs, by the way, not naked or anything of that nature.
Let me just drill down, and the record just may be silent, but in your brief, 4th line, statement of facts, it was discovered, passive voice, that the clandestinely taking pictures. I'm trying to get a picture of it was discovered, because I can imagine, I don't want to, well, let me stop there. It was discovered. What does the record tell us about how it was discovered?
I believe in looking at the underline which was attached, which is the transcript of the hearing at the lower court, that the plaintiff, it is pretty vague, and I would answer that 2 ways, that I think the burden, again, would be on the plaintiff, the victim, to show that the defendant intended for her to find out about it, which it's devoid of, and B, oppositely, meaning I think if any probative evidence is to the contrary, where I think the plaintiff in that, the victim in the statement said, and you're right, passively, that it was only found out through a corporate investigation, but it is devoid of real specificity as to how it got from point A, him doing the act, to point B, her finding out. But what it's certainly silent on in terms of probative proof for the plaintiff is that it came from him to her.
Right, but so let me, maybe a harder question, maybe an unfair question. Over 1,000 photos.
Right.
I don't know if we're in the land of inference or in the land of speculation about him wanting her to find out. I mean, at some point, so many photos in the same physical space, I'm trying to understand how it's possible that he could reasonably believe she wouldn't find out. And if she, I don't know if that's speculation or inference and where the burden lies. You see what I'm struggling with?
Yes. Well, first of all, she didn't find out, and you're right, the record is devoid as to how it got from point A to point B, but I think if he wanted her to find out, there were 1,000 better ways and easier ways and more direct ways to have done it. A, say something to her, hey, by the way, I'm taking your photo, or B, take her photo right in front of her, or fill in the blanks. There's too many to name.
Well, he did approach her on her walk, and he did, that's a reasonable inference that could be drawn, and he did text her.
I don't know
That's two instances, which I'm not sure that your argument applies to those. It does apply to the other incident, if you will, which is the 900 photographs.
Judge, I don't think that he approached her. I don't think there's any evidence that there was any interaction, either certainly verbal and even eye contact or anything. I think the only testimony in the record is that she was on a street, he was on the same street, and she saw him, period, which I think really gets to the point.
In light of the investigation, and this is the first time that that's ever happened, I don't think that it's an unreasonable inference. It's a possible inference that the judge could draw that he was continuing harassive activity.
But again, harassing activity is a generic term that, if you look at the law, really requires more than these people are on the same street. It requires some furtive action from the defendant that is either malicious or willful or directed at her, and it's just too tenuous. Even if you believe the judge had a reasonable inference that those two people literally being on the same street is enough to infer that he did that purposefully, despite it being late at night and no evidence.
Context matter? The timing of that was right after, I believe he was fired after the course of an investigation in which he was being investigated ostensibly for stalking type of activity. And lo and behold, on the day he gets fired for the first time, he's walking on the street where she happens to be. Couldn't that be viewed as escalating conduct characterized by vengefulness?
Maybe if there was something more, for example, evidence that he knew she would be there, or some communication, anything, a wave, a hello, never mind something violent or threatening or hate words or something belligerent or malicious or willful. So even if Your Honor is right and the judge it was a permissible inference to add 1 + 1 just on context, that first you have the photos, then you have the firing, then you have two people, same place, same time. I do think 258E requires more to fit one of the three prongs of wrongdoing, never mind that there are coincidences. And I understand that judge might have some discretion to find it wasn't.
Counselor, the crime of criminal harassment, which is a way to get a 258E,
Right,
does not require the intent to cause fear, intimidation, abuse, or damage to property. So why doesn't his acts fall within crime of criminal harassment?
Well, I'm looking at the jury instructions for criminal harassment, and I think first of all that it would be difficult for the plaintiff to prove that the action, I mean, first of all, it's unclear to me at least that whether or not one needs to be charged and or convicted. It says under the exception to 258E that it could either be the three instances, it could be some sort of irrelevant forcible rape or something, or they committed the crime, I think is the verbiage, as to the third bundle of exceptions or ways to prove it. And frankly, I'm sorry, I don't know the answer to it. It feels like either that person should be charged, if not convicted, but directly, if I'm wrong about that, and it could just be that it fits the prongs of those, and whether or not that would mean beyond a reasonable doubt, because it would have to be committed the crime of that. But putting that aside, I think most strongly, to prove the second element, the Commonwealth must prove beyond a reasonable doubt the defendant intended to target with each act. By target, I mean the act was directed at the victim and the defendant intended the alleged victim know that each act was directed at them, which brings it back, I suppose, to Judge Neyman's question. Can we infer that just the fact that he's taken so many and there's so volume that, you know, like there's some instances where people want to be found out, that we can imply that by him doing it surreptitiously, clandestinely, and that even though there were thousands of better ways to communicate it if he really wanted to, the judge could reasonably infer that by just sheer volume he intended it. I don't think it rises to that.
I don't suppose you're familiar with Commonwealth versus Brennan? Are you familiar with that case?
Not offhand.
Okay.
Can I, you quoted at length from O'Brien v. Borowski.
Yes.
And I apologize that I haven't had time to drill down on this myself, but what I'm struggling with is this seems to, the block quote you have on pages 6 and 7 is articulating the difference between criminal harassment under 265-43A and the civil order that we're talking about here, 258E, Section 1. If the court went to so much, did so much work to distinguish the two of them, but you can get a 258E order by satisfying 265-43A, why bother distinguishing them? I think that I don't know if you understand my question. Can you get, I think Justice Ditkoff's point was, you can get a 258E order by satisfying the criminal harassment statute.
Right.
And if that's true, why is there any analytical value in distinguishing the elements of 258E from 265, Section 43A, as the SJC did in O'Brien? If you have any thoughts on that, we can figure out the answer, but if you have any thoughts on that,
I'm so
here's your
sorry,
chance.
Judge. I'm not following the
That's
question.
fine. I understand.
Really,
it's a difficult question.
I just want to make sure I understand. Your argument in response to Justice Ditkoff's question is it doesn't meet 43A, the criminal harassment statute here, because of the second element wasn't met. The second element is that the defendant intended to target the victim with each act. And you were asking us to look at the supplemental portion of that instruction, which says by target, I mean each act was directed at the victim, and more importantly for you, it's the defendant intended that the victim know that each act was directed at them. And you're saying that the photographs were taken surreptitiously, there's no evidence that those acts were known by the victim to have been directed at her. Am I summarizing your argument correctly?
that's the primary argument, and now you've reminded me of my second. But the answer to that is yes. But I also think secondarily, and I think importantly, I don't believe it even reaches the level, and perhaps it's closer and more discretionary and more arguable, the willful and malicious conduct. I think that what you summarized is argument one, but I think argument two, again, I do think the gravamen of a 258E is really to prevent, and carving up a small exception, either speech that is directed at someone, fighting words meant to scare them, meant to fear them, or actions that are similarly intended to scare them, put them in fear, be malicious and willful, and where the probative evidence is lacking that his intent was to do so, but instead to do something, you know, for his own pleasures or to be creepy or whatever it is. I don't think it either fits the letter of the law or the spirit of the law, which is to prevent people from scaring people intentionally.
See, Justice Ditkoff, anything further? Anything further? Seeing no further questions, thank you, counsel, for your time. We have no brief from the appellee, so the case is submitted.
Thank you very much, Your Honors.
Calling our second case on the list, docket 24P 700, Rapaport v. Rapaport. I would remind counsel for both parties again that this case is partially impounded. Please refrain from referencing the children by name, and please refrain from referencing any impounded material during argument. And we will hear first from counsel for the appellant, Attorney Hacker.
Good morning. May it please the court, my name is Elisa Hacker, and I represent the appellant, who is also the plaintiff in the underlying action. He's here with me in the courtroom today, James Rapaport, Jr. I've actually representing him since the filing of the divorce, going on 5 years ago in May of 2020. This case at heart involves the removal of Mr. Rapaport and his former spouse's 2 minor children to Wisconsin. It is my argument that the trial court erred in allowing the removal of the 2 minor children to Wisconsin to move there with their mother. My argument is that she erred in several different manners, but the first one is that she applied the wrong standard for removal. This case started out with a bang. Mom moved to Wisconsin with the children, and she was ordered back on a temporary order. This is at the height of COVID. If you'll recall, this was a telephone hearing. In the middle of the summer of 2020, the court hastily made a temporary order for physical custody to mother and for a temporary parenting plan. There were no further inquiries into it or changes to the parenting plan going forward from that. That would have, if it had been an official parenting plan that had either been reached by agreement of the parties or after a trial where a judgment was entered awarding mom primary physical custody, then the Giannis test would have applied, which is a case from way back in 1985 when these parties were actually toddlers, minors themselves. So it's a very old case on the standard giving the primary parent a real advantage. And if it is proven that the primary parent has a real advantage to moving, it's sort of a slam dunk thereafter if children are allowed to be removed from the Commonwealth. Our argument is that the Mason case from 2006 actually should have been applied, which is for parties who have shared custody, physical custody.
Right, but assuming we take the view that it's beyond our power to change that, given in Miller and other recent cases, the SJC has made clear that Giannis still controls. What next?
Well, our argument is that even if Giannis controls, that the judge made an error in not, even after the trial judge applies Giannis' real advantage, the judge is still supposed to apply best interest to the children. It was not in these children's best interest to be moved to Wisconsin.
Do you not, on the issue, there's a preliminary question under Giannis, I think, about who, before you get to the real advantage piece of it, who has, what the status of custody, the functional test. And do you concede that the mother has had, under the functional test, has had, at the relevant period, primary physical custody?
Absolutely not, Your Honor.
Okay, can you go in, explain again why?
No, the functional things that the court is supposed to look at is things like everyday things that all parents do for their children, getting them up and getting ready for school, taking them to school, helping them with homework. These children have a lot of special needs, both of them. The older child, as the court knows from our brief and from the record, had been hospitalized and had some very, very serious mental health issues. The younger child is also has some issues with ADHD and is on an IEP. Both parents were very, very involved with the care of these 2 very special needs children. during a very difficult time that happened to coincide with the beginning of the pandemic. My client was absolutely around making meals for them, taking them to school, helping them with remote learning online, and even after the separation. The parties were separated for 2 years from May 2020 until his case was tried in June 2022. He continued to operate as a equal parent in that regard.
And but the judge found at the end of the day that the mother had primary physical custody. And so you're asking us to find that the judge, who's an expert here, was wrong.
Yes, Your Honor.
Okay.
That's what we were asking.
And the standard, remind me of the standard, she, I think it's a she, is entitled to a certain amount of deference.
Yes, Judge Teixeira, it's a
Right.
she. Yes, she is, and she has incredible discretion. The probate and family court judges
Right.
have plenary discretion in all matters that they hear.
Right.
But it's our argument that she abused that discretion. First, by not finding that they had shared physical custody, but also in not making specific findings about the children's best interests. The primary focus of the judge's rationale was the benefit to the mother, that she was fragile, that she could not cope here without parenting support from her parents who live in Wisconsin, basically that she had fallen apart after the breakdown of the marriage, and that she would continue to fall apart even though there was a 2-year period between the breakdown of the marriage and the trial of this case, unless she could move home to Wisconsin and have the support of her family
Well,
there.
so the court finds the move to Wisconsin would greatly improve the quality of his life because he will be surrounded by a large network of family who will support him. He'll be afforded an opportunity to start fresh without fear of his peers knowing his mental health journey. Finally, wife's happiness will trickle down. It seems like the wife was not the focus of that, at least as to the boy.
Well, in that particular finding, no, but it's a conclusory statement to say that they were going to have a better life and that was in their best interest there. In fact, the court itself makes comparisons between where the parties lived in Lexington, which was already paying for supports through the IEP, paying for the older child to be in a therapeutic school because he was not able to be supported in the Lexington public schools. It was a really conclusory statement that this place in Wisconsin would be similar. The extended family argument, the wife's family does live there, but the husband's family lives here, including the paternal grandparents and aunts and uncles and cousins and so forth here.
But it's correct that the GAL did a careful job here. I think there were at least 2 GALs, but a GAL initially was concerned about the older child being at this school, being taken out of this school, and actually went and spoke to teacher or teachers, and after this, it seems, in-depth conversation in person with this teacher, I don't know if it's in person, after this conversation with this teacher, changed her mind. And I think one or both GALs, there's one for each child, concluded, or in any event, GALs concluded their recommendation was it was in the child's best interest to go to Wisconsin. In other words, it seems like people are taking their job seriously and making careful, factual findings that the judge is relying on. What do you challenge there?
You are correct, Your Honor. There were 2 GALs, and they were both for both children. It wasn't one for each. It's not like a
Okay.
guardian. So the guardian ad litem, the GAL, is for both. The first one was appointed and then unfortunately took a job in the Middlesex Probate and Family Court. She happens to actually be sitting as an assistant judicial case manager with the original judge. So part of the delay in this case was because we had to have a new judge out of county and a new GAL.
Big recusal list in the record we saw.
Yes. COVID, that, everything. But you're correct, Your Honor, and I am making an argument with a straight face that all 3 of these experts with lots of experience who cared very much and tried very hard, they all got it wrong. And that is because this is very discretionary, and in my view, they focused on the wrong factors. They focused on the benefit to the mother and not the best interests of the children. The other standard under the well-established law of best interests of the children is not just them. They left all of their therapeutic supports here, the therapeutic school, they left their psychiatrist, they left their psychologist, they left their friends, they left their academic support, they left everyone here. But let's not forget about their other parent who is here. And their other parent has a 3rd child with his new partner. They left behind their sister, with whom both of them have a very close relationship, which is reported by the guardian ad litem and actually by the judge as well. They didn't focus on those factors as much as they focused on mother's well-being.
Can I focus you for a second on the visitation part of the judge's ultimate findings? I went through it just this morning very carefully, and so I think I understand the details. Did you propose at any point an alternative, assuming the point that removal is appropriate, and now we're in the land of visitation with the children in Wisconsin? Did you propose an alternative to the judge's visitation schedule that you thought would be more equitable?
Yes, we did, Your Honor. The visitation schedule, as it is, has proved to be horrible. The judge gave father every other weekend, which for children who are in middle school and just starting high school is very disruptive and has proved to be very disruptive. In fact, so disruptive for the older child who was thrown into public high school, he actually came out for a visit in April and hasn't gone back. He's here now. The younger child continues to come and visit for a weekend at a time. We proposed something that would be more tailored around holidays and vacation time and over the summer.
Can you give me the record citation to that? I couldn't find it. Is there a record is it in the record what your alternative visitation schedule was?
No, because in the strange way that the probate and family court works, when we submit proposed judgments, findings, and so forth, they are not a part of the record.
Okay.
They are not kept with the
Okay.
court file.
Did you say the boy is in Massachusetts now?
He is. He's been living with my client, first in Burlington in a rental apartment, and now he's bought a house in Lexington. He's been here for going upon a year in April. And he is back in therapeutic school, and that is paid for 100% by my client. After some difficulties, mother finally relented and sent his medications, and actually finally relented and agreed to have him start seeing his psychiatrist here. He's seeing a new psychologist, and she agreed to have him enrolled in this therapeutic school over the summer and for the fall, but has not agreed that it will be a permanent thing.
And was this approved by the court? I mean, if the parents agreed, it doesn't need to be, but just
It has
wondering
not been approved by the court, has not been addressed by the court. I don't want to give the implication or the impression that the court didn't want to approve it. It hasn't been addressed by them.
So barring modification, the judge's order lasts until emancipation, correct?
At 18.
This is 18.
Well, actually, for children, the custody and visitation order is good until they're 18. Emancipation is not until they are 18 and then join the military or get married or become independent or graduate from college or turn 23.
Got it.
so the girl is still in Wisconsin?
She is. And she comes out once a weekend, 1 weekend a month, and then she came out for a total of 5 weeks last summer and for several days over the holidays. And she'll be out for a week in March for her spring break.
So before you run out of time, I have a couple of questions. And the first one is, I just want to make sure I understand your first argument. We don't have the power, obviously, to overrule the SJC. On occasion, we'd like to have it, but I'm going to put that aside. Is your fundamental argument essentially what Justices Gantz and Gaziano wrote in their concurrence? Is that a pretty decent summary of the content of your argument?
Absolutely, Your Honor. I believe that a best interest of the children should be the plenary standard for everyone. Giannis, as I mentioned, was decided in 1985,
Sure.
which was a long time ago when there were some more gender-biased views on parenting. Miller is much more recent, where Justice Gantz wrote that concurrence. That's from 2018. It's unfortunate that nothing has gone up yet to do what he asked everyone to do in that concurrence, is to make the best interest the plenary standard for everyone. Because what happens, just like in this case, is one little temporary order from a 10-minute telephone hearing is what the GALs and the lower court judge hung their hats on, without taking a real view at the real parenting that was going on in this family.
And you started your argument by saying that Mason should apply here and not Giannis. And again, is the substance of your argument essentially that the judge made an error of law in determining that the mother has or should have primary physical custody?
Yes,
Okay.
because Mason deals with people who have shared physical custody and then goes straight to best interest. Now, in best interest, one of the things that the judge is supposed to consider is the best interest of everyone, the children and both parents. But it sort of bypasses that huge advantage that the quote, sole custodial parent gets for having sole custody
So
under Giannis.
it's really interesting to me that the two children are now living in different places, because my immediate reaction when I read the judge's opinion was there's no analysis of whether the children should have different answers. And I'm wondering, was it tried that way? Was it tried in the sense that the two kids were going to go to the same place? Or did the judge sort of just miss, maybe there's different answers for different children?
It was tried by everyone, including myself and my opposing counsel and the judge, as the kids go together. But I will acknowledge my client from the beginning had proposed something along the lines of what has actually happened, because he recognized the particular needs of his children and that their particular special needs sometimes make it difficult for them to get along. But that's just not how it's usually done in the probate court. Maybe going forward, as we have more of an understanding of special needs and mental health issues, it will be, but it was tried as...
Somewhat ironic result in that the one who wanted to stay in Massachusetts is in Wisconsin, and the one who wanted to go to Wisconsin is back in Massachusetts, but...
It is very ironic.
So in practice now, currently, am I right that the mother, if she wants to come visit, or she wants to visit the son, she's on her own dime flying to Massachusetts?
Which she has only done once in the last year, but yes.
Okay, but that's the informal agreement that they have?
Yes.
Okay. Nothing. Thank you.
Your time is up. Seeing nothing further, thank you for your argument.
Thank you.
And Attorney Curhan, good morning.
Good morning. May it please the court, Dana Curhan for the mother. We're asking that this court affirm the removal order. To begin with, the court properly applied the Giannis test. There has been one development that is actually a part of the record in regard to, since I filed my brief, I said, you know, the father never filed for direct appellate review, so he's kind of stuck with the results, or stuck with
Record shows that
Giannis.
DAR was denied.
Right. Yeah, they filed it and was denied. That's the law of the case. It's also the law of Massachusetts that Giannis is the existing standard. And Giannis actually does consider the interest of the custodial parent, but only in a very limited way. It considers whether there's a good and sincere reason for the move. So if she was moving out there in order to spite the father, that would be a problem. But she had legitimate reasons for moving out there, and you know, the parties were only in Massachusetts since about 2016. And so they were only out there, and they were only in Massachusetts for a few years before this divorce action was filed. There's no family out here, with the exception of the father. The wife's, the mother's extended family is out in Wisconsin. That's where she's from. So you know, there's a legitimate reason under Giannis for considering her interest. Now, that said, the judge made extensive, fairly extensive findings as to the best interest of the children, I think independent of Giannis, and found that the move was in the best interest of the children. So I think that renders any claimed error harmless. And with regard to whether the Mason test should apply, and whether that, again, as this panel noted, it depends on whether the mother was a primary custodial parent. It was a temporary order that gives her primary physical custody that was in place for 3 years before this case was decided. But before that, the mother was a stay-at-home mom. She was the primary caretaker of the children. The GALs both recognized that. The judge made that finding, and I don't see the error here.
On the daughter, it seemed to me that the daughter, in her statements, made some compelling arguments that she wanted to stay here. There seemed to be some disagreement on a factual level about the number of friends, her social network in the area. She seemed to herself say, I like it here. I have friends here. She also seemed to say, I like my grandparents in Wisconsin. I like going outdoors with my grandparents. In other words, I'm not sure what I'm saying, except that it seems that there's a better argument for the daughter saying, or she seemed to express more clearly she had reasons to stay in Massachusetts. If you could address that and how the GALs got past that.
Well, I mean, I think the GALs and the judge said, okay, that's obviously somebody who's here for a number of years and goes to school here is going to have some friends. The judge found that she was not all that connected to the community. She hadn't been there that long. She takes singing lessons, but other than that, doesn't really do a lot of extracurricular activities. So, you know, I think the judge can look at that and say, there is a, and the judge, I guess, used the term real advantage to her moving. That wasn't an application of the real advantage test. I think the judge actually made a finding that it would be in her best interest and to her advantage to move to Wisconsin. So, you know, I don't think we can say that the judge made an error or that the findings of the GALs were unsupported just because, you know, they were countervailing factors.
Thank you.
And, you know, obviously she's out there and she's not, she hasn't moved back here, you know, unlike the son. So
what do we do about the fact that as to the son, we're being asked to affirm a ruling that doesn't seem to be operative anymore?
well, I mean, this has never been approved by the judge. It's not a permanent order. And it may be, I mean, the reality is he's going to turn 16 in March. The older he gets and the closer he gets to 18, the more, probably the more say he's going to have in where he lives. And in 2 years, he's going to be able to decide wherever he wants to live. But I think legally, this order should be in effect. And you know, if the court wants to modify it, that's fine. They can go back to court and modify it. And they can make an agreement that, you know, I mean, a lot of this is news to me, but the parties can make an agreement that sort of alters the scope of that, of the order, but that doesn't mean that the order should be invalidated just because the son wanted to move back here. I mean, he was the one actually who was pretty adamant that he wanted to move. So I don't think that has any effect on the validity of the order. I think looking at the father makes a number of arguments about certain findings aren't supported by the record. I'm not going to get in the weeds and try to go through every one of them. I have gone through them in my brief, but suffice it to say that those findings that are challenged are well supported by the record. And
I should know this, and I think I read this somewhere, but I just want to check. Did the judge explicitly credit the findings of both GALs?
yes. Unless there are any further questions by the court, I will leave the remaining points of the brief.
Okay. Thank you very much.
Thank you.
The case is submitted. Let me just say for the record, these are incredibly difficult cases. This in particular is an interesting and difficult case. Both parties have been very well represented and will take the case under advisement.
Thank you.
Calling our third case on the list, docket 24-318, Department of Children and Families versus Mother. And before we begin, let me just remind counsel that this case is impounded. Please do not reference the names of the children. Please do not reference any impounded material in your presentation. And we will hear from counsel for mother, Attorney Diaz.
Yes, thank you. Good morning. May it please the court, Myrna Diaz on behalf of Mother, the appellant in this matter. Your Honors, what we have here today is a termination of parental rights to a mother who, throughout the entire case, the theme ran that mother had many disabilities. Mother also has a long history with the Department of Children and Families. She has been with the Department of Children and Families, had involvement with the Department of Children and Families since around 2014 when her first child was born. These two children that I'm speaking of now are not part of this case, as this is just by way of background. These children are not part of this specific case, and her parental rights as to those children is intact, and they are under legal guardianship with paternal grandparents. But moving forward to this case was initially, a 51A was filed on August 24th, 2020, about a month after, a little bit under a month after the child in this specific case was born. The child was born with many medical needs. That's in the record. And mother was provided time at the hospital in order to learn how to care for the child due to the many medical issues that this child had at the time. While mother was trying to learn all the ways to take care of her child, the 51A was filed by the hospital. In the 51A, there is mention by the nurse that mother has problems remembering and being able to essentially retain the information that is being taught to her while this child is in the hospital. Mother was unable to leave from the hospital with her child, and her child was eventually removed and placed into a foster home. So while the mother was working with the department, it is littered through the entire record and in the judge's findings and the conclusions of law about mother's cognitive limitations, about mother's learning disabilities, the results of mother's neuropsychological evaluation, which the court investigation gives us an in-depth look as to what the results were. However, the department did not provide mother with any accommodations to assist mother in order to get her to a place where she would be able to parent her child independently.
I have a problem with that. I mean, it seems to me, and obviously the other parties spoke about this, and actually I found particularly helpful the child's brief listing each of the things that you, I guess, claimed were shortcomings, failure to provide accommodations, and they, citing the record, illustrated examples that no, DCF actually tried to meet her where she was on these things. I don't know how you answer this question shortly and succinctly, but it seemed to me that the gist of it was the DCF was doing everything they could to meet her where she was. And the problem was more, for many reasons, including hardship, she was simply not making progress.
Yes.
Go ahead and address that.
Yes, I will attempt to address that, Your Honor. So the department did provide mother with certain services. They provide her with an action plan. They actually provided her with 3 action plans throughout the pendency of the case. However, nothing in that action plan actually addressed ways to help mother. So in her action plan, which remained unchanged throughout the entire pendency of the case, the action plan remained unchanged. The action plan required mother to undergo a neuropsychological evaluation, which she did. It required her to finish a parenting class, which she did. It required her to work with a parent aide, which she attempted to. And it required her also to have a parent evaluation performed, which she did that, and I will concede that it is in the record that mother said that she did not want to give that report over to the department. Regarding the parent aide, mother Mother testified, and it tells us in the record that Mother testified that she felt that working with the parent aide wasn't helping her and she wasn't learning anything because there were no goals in place. So at that point, Mother, at some point towards 2023, I believe, Mother was given a new social worker. So that social worker testified at the trial. She was asked if the department had a disability policy in place. And that social worker testified that she honestly didn't know. Then she was asked if a calendar of appointments was provided to Mother due to the fact that Mother, she had problems remembering and retaining information. So these are one of the ways that the department could have accommodated Mother. The department...
So sorry, you're saying that, to drill down on that one at least,
Yes.
I get that she, because of the drowning incident, maybe because of many pressures in her life, had a hard time remembering things. She said repeatedly, I need you to repeat things to me a bunch of times. You're saying, but the gist of the record is, DCF says, come on, we did repeat these things to her. We did tell her repeatedly what we wanted her to do. And she just, it wasn't that she was forgetting, it was that she wasn't following through. Is that a fair characterization of the record?
That is, Your Honor. And that is, I will concede that is when one reads the record, that is what was happening at the time. One of the issues is, Your Honor, is that the department's disability policy, which which was enacted in 2022, it in there clearly states, Your Honor, what the department needs to do when they have a parent that has cognitive limitations or disabilities such as a mother here. So I attached a copy of that disability policy to my addendum as well. But some of the things in there is that the department, and I apologize for all the flipping, the department they have at their disposal, they have experts that they can sit down and conference the case with. They have other resources that they can reach out to. They can sit down, they can have a meeting with Mother, with
Okay,
Mother's
so I'm sure they have lots of options. Can you identify for me a specific thing maybe that you articulated that you claim they could have done that they didn't do, that they should have done, that the department in their briefing has not addressed?
So, Your Honor, one of the things that they could have done is they could have sat down with Mother, and they could have sat down with Mother's counsel as well. They could have sat down together and came up with a plan of how to better work with Mother, how to better effectively work with Mother through her disability. And
You mean improving the action plan? In other words, modifying the action plan?
modifying the action plan,
Okay.
sitting down with Mother and her attorney, and reviewing ways in which they could have change the action plan, find ways that they could work with Mother to help her better understand and be able to get her up to speed to be able to care for her daughter. Also in the record, Your Honor, there's also instances where Mother is reaching out to the department in writing saying, you're not providing me help, you're not providing me services, you're not showing me how I'm going to be able to take care of my daughter. Mother was allowed to participate.
Where is that?
Sorry.
Where's that?
Oh, yes. I wrote that down, Your Honor, in case Your Honor asked. There's the findings of fact 120. There was an email where Mother emails the department asking for help, saying that her child is wants to know what's going on with her child medically, and going forward, what services to help her. Findings of fact 121 expressed her concern to the department about being left out of her child's medical appointments and all other services her child was involved in. Findings of fact 123, that is when Mother decided to terminate the services of the parent aide because she felt that no goals had been established to work on.
Right. Well, I want to shift here for a second, if I can, to the child. I think everybody understands the child has profound problems.
Yes.
I think being followed by 8 specialists.
Yes.
And DCF makes the argument quite clearly and compellingly that even if under the ADA and the disability policy, DCF could have done more, that isn't a reason to ignore the best interest standard for the child. And this case is a poster child for the wisdom of that rule. How do you answer in a hypothetical way if this mother has custody of this kid, she's literally never fed the child because of the G-tube? How do you answer that concern, that profound concern that this child, the well-being of this child?
And, Your Honor, that is going just back to where mother's asking, just regarding the G-tube and the feeding and the specialists and all the medical needs that the child has. Mother asked the department to allow her to do these things. She was asking them, show me how to do these things. I want to learn. During visits, during the supervised visits with the child, mother was allowed to feed her applesauce or feed her a bottle of milk, but that was it. It was obviously very limited. And yes, mother never was able to feed this child through her G-tube. She was never given that opportunity to do so, and that's what—
So, sorry, you're saying that she was never actually permitted?
Sorry, permitted, yes, thank you.
So whoever the supervisors were, I'm not using the right term, would not allow her to try to feed the child with the G-tube?
Right, so when mother had her supervised visits that were, I believe, 2 hours in a supervision center, mother was only allowed to feed the child snacks. So it would be like applesauce or a bottle of milk, but she was never allowed to actually feed her through the G-tube. That was never something that she was permitted to do. She was never, in the record, it doesn't state anywhere where she was actually taken to a medical appointment to be taught how to do these things. So she wasn't permitted, she wasn't taught how to do these things or be able to take care of her child. So do concede that at the time mother was unfit, but will mother be unfit in forever? We will never know, because she wasn't given that opportunity to be allowed to possibly get to the level of being fit and being able to care for her child. So back to the best interest question, I don't know if I answered that or not, Your Honor, but if mother had been given the opportunity and the right assistance, the right accommodations, it would have been in her best interest to be reunified with her mother. Her mother was never able to parent her. She was taken from the NICU to a foster home, and mother was not allowed to do any of the things that the judge in his finding gives us details of how well the foster mother is taking care of the child. Well, the foster mother is able to reside with the child, so the foster mother is able to do all of these things and is obviously able to do these things well because she's with the child every single day. Mothers was permitted to, it was, can't think of the word, I apologize. Through Zoom, like telehealth, be able to participate in telehealth appointments. So she wasn't able to actually be at these appointments, physically present in order to take part in these. So these are things that again, mother wasn't permitted to do. We're not going to know if mother was ever going to be able to become fit because she wasn't given the accommodations that she needed. And I understand that there's a big argument with adoption of Gregory, which goes against everything that I'm saying, because it says that a parent with a disability is not supposed to use their disability as a defense at the time of the appeal, and that is not what we're doing in this case. It was throughout the entire case that mother's cognitive limitation, her learning disabilities, it was known to the department.
But when you have
a care and protection, once a care and protection is filed, that is when a parent or a child is offered counsel. And at that—
Counselor, why would we believe that the mother would take advantage of such services when she doesn't do the parent training at the hospital? The parent aid gets canceled because of her cancellations. She stops going to visits. She won't give the parenting evaluation. It's not really a record that suggests that services would be accepted or useful. How do we get past that?
Well, Your Honor, I think we get past that. As I pointed out earlier, mother asked the department for services. She says, I want you to give me services. I want you to help me so that I can take care of my daughter. I feel alone. So she is reaching out and she's saying, what you're giving me is not enough. I need more. And it may not have been in the formal way of, filing a motion or presenting it to the court.
But is this the findings 120 to 123 that you're talking about?
Yes.
Because, that's a situation where she's actively refusing home visits and services and saying, I want different services, but why would we think that she wouldn't have a problem with whatever other services?
I think, and I'm not medically trained at all, but I believe that if the department had actually sat down with their experts that they have at their disposal, they could have found different ways of approaching mother and working with her. Because with the parent aid, her refusal, and she testified to this, she felt there were no goals that were set up for her to work on. They weren't doing anything. She didn't feel that it was proactive enough as to get her to the goal that she wanted at the time, and that was to be able to be reunified with her daughter and be able to parent her daughter.
Your time has expired, but let me see if there are any further questions. There are not. Thank you for your argument, and also thank you for your very concise and targeted reply brief, which I found to be very helpful.
Thank you very much.
We'll hear from counsel for the department first. Good morning.
Morning. May it please the court, Jeremy Bayless for the Department of Children and Families. Justice Wood, you asked Mother's Counsel what is something that the department could have done, didn't do, should have done, and might have made a difference. And Mother's answer was to sit down with her and discuss options. The record is very clear that after the receipt of the neuropsychological evaluation, after the department had internal meetings, they were very well detailed by my brother in his briefing, that the social worker regularly tried to sit down with Mother to discuss her action plan. Those meetings would be going over whether the action plan was currently meeting her needs, whether there was something that could have been added that might have been a benefit to her, and Mother refused to do so. The neuropsych said that Mother needed to participate in a parenting class. Mother attended the class. The department had concerns about her retention, so it asked her to do it again, but fully credited that participation. Mother testified that she learned nothing from the parenting class. It said that she should get a parenting aid. Mother was referred to a parenting aid twice. After the first parenting aid cycle was terminated, she got it back again. The same with the parenting evaluation. This is not simply a case of a parent with a disability. It is a parent who is unwilling to work with the department to access things that might help her with her disability. Furthermore, this is, and I guess sort of reflective of that lack of interest in engaging in services in actuality, Mother didn't raise any of these concerns with the Department's provision of services through any of the mechanisms that would allow either the department's internal review process or the court to properly evaluate them at a time when an evident factual record could be done and something could be done that might help determine whether or not something could be different if there was another service. Even if there was something out there that Mother would accept that would help, evaluating whether or not that could have overcome her profound disability and this child's profound needs is something that would obviously need to have been addressed with facts and evidence earlier in the proceedings. That's why, Gregory, that's why extensive case law provides that these arguments can't be raised for the first time on appeal. It is simply asking this court to engage in hindsight-based speculation. But I think what this comes down to fundamentally is that Mother can't or won't maintain a regular schedule and keep track of appointments. This has happened with her older children. One of the older children, a major concern was that she had medical difficulties with her eyesight, and Mother simply said it was fine and didn't take her to the hospital. The extent to which that is attributable to her disability versus some other issue that Mother is having is relevant in the terms of it affects the department's action planning and efforts, which the court found were not just reasonable, but in fact went beyond reasonable. But it's also somewhat irrelevant to whether or not she's able to parent the child in the long term, because as case law tells us, fault is not the issue. Even if Mother were purely faultless, and this was attributable entirely to things outside of her control, the analysis is whether or not this child can, at some reasonable point, be safely parented in her parents' custody. And the record reflects that with supports, with there's a footnote in the findings that the social worker testified that when appointments were put into mother's phone so that she would get a ping, she still wasn't attending them. So with that level of support being done, mother simply couldn't do it.
So the indefinite piece of this is termination, this is forever, and we're predicting the future. Will the mother ever be fit to have a role in her child's life? What's your, can you address that?
Sure. I guess I would start by saying the analysis is less could she ever, and it's within, I am paraphrasing, but within a reasonable, it cannot be an indefinite, a mere that faint hope that mother could get better. It needs to be something where this child could have a childhood where they are safe with an understanding that they are in their permanent place. And the problem is that this is a mother who has been working with the department through, this is her third child, none of them in her custody, years. And she's been given support. She's been given supports by the department. She took particular issue with the department after the goal change, which is when what really triggered her full withdrawal from any engagement from DCF services. But she's been working with other people as well. The hospital, while she was there, tried to get her to attend trainings on how to take care of her child, and she never did it. When she was supposed to help with feeding the child, she instead went to Chinatown for 3 hours for lunch and was irritated that the hospital was trying to reach her for that scheduled deal.
I remember that, and I remember that vividly in the record. Opposing counsel makes the claim that she was asking to learn how to feed the child after that period, once the child was out of the NICU and in the custody of. Can you address that specifically? Whether the record support for efforts to help her learn how to feed the child through the G-tube?
So it is accurate that she was never given the chance to use the G-tube. Now, the problem with that is that is a somewhat complicated procedure. It is obviously much more complicated than simply giving the child snacks. And mother was, my understanding is, several stages of education behind where she needed to be, which is why, and this was actually part of an internal department review at a permanency planning conference in 2021. The department determined it should be doing more. And so that was when the efforts to put mother in contact with the child's medical providers were made. And then what happened from those efforts was mother would schedule an appointment for a consult, and then she wouldn't attend, or she didn't do the follow-through to actually understand what needed to be done to care for the child. And so I would contend that sort of actually using the G-tube is something that would have to happen after that education process, because it's something that could have a pretty significant impact on the child. And specifically to mothers asking for services, the record shows that she would send those emails, and then she would refuse to meet with the social worker. And she would say that, she's not gonna, the parenting evaluator is not helpful because they're reporting back to the department. And so she would say one thing and do another.
I was perplexed by your motion to strike. This neuropsych evaluation was marked for ID, and I always understood one of the reasons to mark something for ID is specifically so you can show it to the appellate court. What am I missing? Why can't you put something marked for ID in an appendix?
I am so sorry, I missed that last sentence.
You moved to strike the mother's appendix on the grounds that it had the neuropsych evaluation in it, but that was marked for ID. Why can't you put something marked for ID in an appendix?
Well, the motion to strike, it was not admitted into evidence, and so were there to be an appeal from a decision not to admit it, then it would make sense for there to be a review of it marked for evidence. But for it to be substantively considered as an admitted evidence in the proceedings would be inaccurate.
But you moved to strike it, not just asked us to not consider it substantively. Why'd you move to strike it?
I think that may have just been the avenue that was chosen. If this court is inclined to address simply not considering it substantively. It was considered substantively and cited to as part of the briefing process. I think a resolution of that motion could be simply to not consider it substantively. I am not sure that has a tremendous impact on the appeal because as we all cited to the court investigator report references it, but it was treated as if it was admitted. It was not admitted into evidence, and that distinction was I believe, the request that the appellees had.
Seeing no further questions, thank you, counsel. And Attorney Desmond, good morning.
Good morning. Members of the panel, may it please the court, my name is Joseph Desmond on behalf of the appellee child. First, on the motion to strike, the judge specifically said that neuropsych report was not admitted into evidence. It was objected to by mother and was not admitted into evidence, so it would be child's position that it is not part of the record and hence not properly.
Why wouldn't it be part of the record? The record is everything on file with the lower court. That's what the rule says.
It was not admitted into evidence, hence I concur with my brother then that it would not be substantively considered, but it was part of the record in the court.
Okay.
I have intelligence testing. Is there any evidence? I was looking high and low for evidence of the mother's intelligence testing, and I couldn't find any. I don't know how important it is, but I guess I'd like to know it. Is there any evidence in the record about the mother's intelligence testing? I thought it would be in the neuropsych report, but I understood not in the record.
I don't recall any. She did, not in the record. It could have been in the record because, as I noted in my brief, she had a prior neuropsych that she did not want to disclose.
Okay.
So,
thank you.
no, I don't know of any other evidence.
Thank you.
As to the child, I wanted to focus on the cases which focus on the fitness of a parent for a particular child. The child concurs with the argument of DCF as to the global unfitness of mother, but the case law as to a particular child is detailed in conclusions of Law 11 and 12, holding in summary fashion that parental unfitness must be evaluated in the context of a particular child's needs, and it is indeed conceivable that a parent might be fit to bring up one child, but unfit to bring up another. The judge in the lower court found that this case law is applicable, considering the high degree of special needs of the child in this case, and mother did not object. Particularly as it relates to mother's arguments for reasonable efforts, ADA. In this case, the prior two children mother showed very parallel concerns with the lack of medical treatment, the lack of ability to follow feeding directions, which are critical to the welfare of the child. So there was no blank slate. Going into this child, the third child, the concerns were known. There was no need to evaluate all this evaluation. It was known what the concerns were from day one. And from day one, before the child was even out of the hospital, mother was not responding. And that never changed. So that, as it goes to a particular child in this case, but it also relates to those ADA arguments, there is a much, much weaker argument in this case because the process of discovering the deficits was essentially complete at the time the child was born. And mother did not take the necessary steps to overcome those deficits. The child, well developed in the record, the feeding regimen here was demanding, complicated since birth. A G-tube was inserted into the belly when the child was about 6 months old. As far as mother having the chance to feed the child through that tube in the belly, she was instructed in that, and the record reflects that as well. She never did it because a couple of reasons. One, it takes about an hour. I think the foster mother testified at trial, and it's otherwise in the record. The whole process takes about an hour. During that time, there's some mechanisms in place that need to be kept in place, so the child needs to sit stock still. That's not a great visit. For the mother only had a 1-hour visit, and she liked to play with the child, to her credit. But to sit with the child stock still while the child is fed is not realistic. There was a parent aide appointed to try to bring mother along in this process, but mother terminated the service. So the idea that mother now says that I was not given that chance is not a good argument in light of those facts. As to the neuropsych evaluation, somehow spawning the need for a re-examination of her capacity in some unspecified complete reset of the case approach is just revisionist history. By the time the child was born, DCF was well familiar with mother's capacity, and it just wasn't enough. And she had exhibited an unwillingness to learn throughout the case. Also, it's important in this case also to focus on the best interests of the child especially. Mother self-terminated her visits in December of 2022. In the latter half of 2022, she had self-decreased her visits as well. So that goes to the fact is whether or not the best interests of the child are ever going to be served by reunifying with mother. In this case, there's little question that that will not happen. Child was placed with an adoptive foster mother. The evidence from the adoption social worker at trial was that was one of the few instances where the child actually responded to someone and bonded to someone. Even mother said at visits, she doesn't get a response from the child. She's that deeply embedded with her condition. But the adoption social worker said that as soon as the child met the foster mother, who she's still with, there was an immediate reaction. So the best interests of the child, for that and a number of other reasons in the record, would not be served by remand or ruling in mother's favor.
See if there are any further questions. Seeing none, thank you. Helpful arguments, very helpful briefing, and the case is submitted.
Thank you.
We're going to take a brief recess.
Hold on, rise, please. Court is now. Rise, please. This court is now in session. Please be seated.
Good morning again. Calling our next case on the list, docket 24-125, Dunavan v. SHP IV Concord River. We'll hear from counsel for the appellant. Good morning.
Good morning, Your Honors. May it please the Court, my name is Attorney Chris Sobchak. I'm here representing the plaintiffs. We're here asking the Court to vacate and reverse the trial court's ruling on summary judgment on 3 counts. One, on the issue of breach of contract. The Court ruled that the case failed because of parallel evidence, even though parallel evidence was not required. The plaintiffs have argued and pled in their complaint that the facility had an agreement with the 2 individuals to offer them services, to offer them custodial services, and to make a promise to age in place. In the end, the plaintiffs alleged that they've breached all of those promises, and that's the breach of contract claim. The defendants in the court focused on the last part, which is the promise to age in place, which also was part of the additional count of unfair deceptive practices, and the court ruled that because of parallel evidence, you can't proceed on that case. But the court ignored that the basic agreement to provide services was also breached, and that it does not require any parallel evidence. Even if the parallel evidence wasn't ruled, then for the issue of age in place, it was part of the agreement because when the court ruled that the agreement and all the attachments are part of the contract, that included the customer guide, which specifically says, ask this question. Well, if an integrated agreement says, ask this question, the answer likewise should be part of the agreement.
Why is the customer guide a part of the contract?
Because in the contract it specifically says, this is the contract, and here's the attachments that are included, and the customer guide was one of the enumerated attachments. It was not provided initially in discovery, but during deposition, it was a different version was produced, and then stated on the record that it would have been the same version. The only difference was the cover page. So it's actually listed in the attachments. Those are all the documents that are part of the contract, and the consumer guide was one of those attachments.
Does the record, I think what you're saying is that the answer to the question is part of the contract. In the evidence, is there A, any evidence of what was actually asked, and if so, B, what the answer was?
Yes, that's the parallel evidence part. That's the part that...
No, I get that. What's the record citation to the question being asked? And there's no transcript, right?
Right, there's no transcript. It's
right,
in
so
the
what's the
allegations.
evidence?
It's in the affidavits. The affidavits of the plaintiffs, they say that they were promised to age in place. And it was a very simple question. Basically, do you have a 2-person assist? And the answer is yes, because you will be able to age in place and we'll be able to provide you all the services.
Were the affidavits submitted for the first time after the motion for summary judgment was filed?
They were submitted with the second opposition before the motion was considered. The primary opposition was based on procedural issues, and there was no substantive affidavit submitted.
What's your proposition, what's your authority for the proposition that such affidavits filed at that time can be considered as substantive evidence in a summary judgment?
Because that's what literally the court ruled. Says, I'm not going to rule on this until you provide this opposition. So the court asked for it, and it was part of the record for the summary judgment.
You asked for an opposition, but that doesn't mean it's substantive evidence that may be considered, right?
The opposition includes all substantive evidence. So if it's attached to it, if they were to something to be improper or something that contradicts their testimony, the defendants would have moved to strike. But by the time it was considered, all substantive evidence that was before the court was being considered by the court, which includes both the excerpts from the depositions that were in the defendant's motion and the affidavits that were in the response.
Okay.
And I believe also, and I don't have the site in front of me, in the depositions that they were asked, they were part of the original motion. The defense actually included their deposition testimony when they said they were asked to age in place, because that was part of their argument is that it's only parallel evidence, and therefore they offered the parallel evidence there. I just don't have the exact deposition citation on top of my head.
That's helpful, thank you. I want to take a step back. Was the summary judgment motion, and we'll get to the 56F response in a minute, but when the summary judgment motion, was that served upon you under Rule 9A?
Yes, it was.
Okay, I'm looking in the record appendix at page 79 where it contains the joint statement of facts. I didn't see any responses from you, either saying admitted, disputed. Did you ever file a response to the joint statement of facts?
Yes, Your Honor, and not with the initial one, with the second refiling. So I'm trying to pull up the...
Where in the record appendix can I find that?
That's what I'm pulling up right now, Your Honor.
I saw your opposition, the supplemental opposition, but I did not see any response to the joint statement of facts. But again, I may have missed it.
And I don't see it in the random. I don't know if it was included or not. I do know it was included with the defendant's second 9A filing of the motion.
I'm going to ask Brother Counsel the same question as well, but if it's
and if
not...
I don't find it right here, Your Honor, if it is there, I will submit it after the arguments. But I believe I did answer it. It was with the second filing, not with the first. And it was before the court, when the court considered it, before the court issued its ruling.
Another question I have, I noticed in the contract, this is at Record Appendix page 157, there's an attachment that contains an arbitration provision, if I'm not mistaken.
Yes, Your Honor.
Why was this case not submitted to arbitration?
Because the arbitration provision is part of every single standard contract that the company uses. In this case, it was never executed. So it's unsigned arbitration provision. The provision's there, but it was never executed by these plaintiffs or these residents.
Very good. Thank you.
Moving on to the second argument is the issue of the simple negligence. Here, the court argued that, as adopted the defense argument, that this is a medical malpractice case and therefore you need an expert opinion. It's not. This is not a medical malpractice case. This is a simple negligence case, and therefore, up to this point, no court in Massachusetts has ever required an expert opinion.
So I have a lot of questions about that. So I don't really know how to break it down, but are you aware of any cases anywhere in the country presenting something like this, assisted living facility, because they're everywhere in America, where somebody's claiming, and the closest I can understand is you're saying there was insufficient staffing, and if there'd been more staffing, these people wouldn't have fallen down and gotten hurt. But so lawsuits like that resulting in reported decisions alleging negligence in an assisted living facility context, like yours, do you know of any cases anywhere reported?
I have not found a single one where prior to this required a non-medical provider to have an expert opinion.
Okay. Wait, sorry, say that again?
I have not found a single case that required an expert against a non-medical provider.
No, okay, well, okay, great. So have you found a reported case, period, involving a negligence suit for insufficient staffing against an assisted living facility?
Not a reported one, no.
Okay. Unreported ones here?
I have not. No.
Okay. And so backing up, the nature of the negligence claim here, I was having a hard time understanding. You talked about the Connie falling, having incidents and harm, I think, not falling. Incident and harm, I think was the way you put it. I don't understand what the specific injury was. Are you saying that she would fall? And if so, in what context was she falling?
So their complaint didn't allege all the specific instances because there's more than 30 of them, but in some instances she would fall and be bruised. In some instances she would be told to hold her urine for multiple hours and be in pain or be embarrassed.
Okay, so all right, and so it seems to me, trying to infer what you're getting at here, the fundamental gripe in this context is a staffing problem. In a medical, I don't know if it's not a medical facility, it's not a medical facility, but a staffing problem in this place. Is that an accurate articulation of your gripe on the negligence claim?
It is one of the elements, yes, Your Honor. It's a staffing issue at a non-medical facility.
Isn't that, how is a layperson supposed to know what an appropriate staffing level is for a place like that or any place that requires staffing?
Well, staffing is just enough people to cover the services that you need.
So it's just common sense?
Common sense. It's an issue of both the cases that were cited by the defendants and the judge in his opinion involve issue of the staffing but at a medical facility. The equivalent issue would be you go to a car dealership and you have a services that we're going to fix your oil change. And we have 70 mechanics on duty. We promised you to get it done in an hour. You're out in an hour. You show up there, and instead of 70 people, they have 1. And you sit there for 9 hours waiting for your car.
That would just be a breach of contract. It wouldn't be a negligence action.
Well, you could plead as a negligence, saying that they negligently staffed their facilities, having 9 different bays, taking in 9 different cars.
And how would you prove that that was a negligent way to staff a car dealership?
Correct. And
how would you prove that?
You would.
How could a juror understand what the proper staffing is for a car dealership? I can understand if a dealership says it'll do it in an hour and they do it in 9 hours, it's a straight breach of contract. But what if they say we're going to do it in 9 hours with our appropriate staffing? Could you sue for negligence under that situation?
In that instance, I would not. If they say we're going to do it in 9 hours and you get it in 9 hours, there would be no harm at all.
So that's not negligence, it's contract.
It is primarily contract. The count of the negligence count was pled in an alternative. But to use the first example, if they say we're going to do it an hour and they do it in 9, the breach of contract is the simplest count, but the negligence is an alternative count saying you had a duty because you made me the promise that you will do it in 1 hour. You failed to do that duty because you did it in 9 hours. The harms may have been that in this case, you just wasted 8 hours of your time. Well, if you were sitting in the lounge watching TV and something else, that may not have been huge. If you were somebody that gets paid $1,000 an hour and you missed on bill, the harms may be different.
And a layperson can figure out what the proper staffing is for a dealership
in that case, it would be simple. If you're going to put that simple, the dealership may have admitted, saying that we have 8 bays and we're going to do a promise in 1 hour, and therefore we established the standard that we'll give it to you in an hour. In this case, they promise to keep you safe, and they say, here is the type of staffing that we will go and have. In their agreement, they say we will have at least 2 on the night shift, 4 on the day shift. So the defendants establish their own minimum standards. So you don't need an expert to tell you that these standards are...
Is there evidence in here that they fell under that?
The evidence, the allegation is that they did because they failed to...
You have evidence. You have evidence for summary judgment. Where's the evidence in the summary judgment record that says that when they agreed to have 4, they had 3? Where am I going to find that?
There isn't, because there was never an answer. That was part of Rule 56. They never identified how many people were there. We have the allegations from the parents, from the children, that said we would have to wait for them to get to her in 2 or 3 hours or 4 hours. I believe there was a testimony in the deposition that they said that sometimes they couldn't get to her because they were dealing with somebody else.
I'm sorry to interrupt you. You've mentioned now 3 times you've referenced the allegation, so I assume you mean the amended complaint, correct?
Yes.
What legal authority do you have that a judge may consider, a court may consider the allegations in a complaint as substantive evidence in a summary judgment analysis? What is your best authority for that proposition?
Authority is that for summary judgment, it's the absence of facts. Here, the duty was on the defendants to establish that there was no evidence, that they provided all the services.
I understand that, but my question's a little bit more specific. You've been asked what the evidence is in a certain context 3 times, and you've referenced the complaint or the allegations. I am wondering, is there authority, a case or a rule that says allegations in a complaint may be considered as substantive evidence in a summary judgment analysis?
No, Your Honor. And in that case, I probably misspoke. The allegations in the complaint track of what the children testified at their depositions and then their affidavits. Basically, the allegations mirror what their testimony was. So the substantive evidence would be the deposition testimony and the affidavits from the children.
Got it. Okay.
It was just that the allegations enumerated them sort of in addressing the issues of what was alleged or what wasn't. There was no evidence during the deposition, during the case, that we only had 2 people or 3 people on that particular time because they was not available. And I'm running out of time, so if I jump to my 3rd issue, is the issue of the emotional distress. The most recent case, I believe, it was the Lemire case from SJC in 2022, decides that when it comes to duty, it's based on custom and practices and on social norms. And then here, although the daughter was not a direct party to the defendant's contract, she was the one that was the healthcare proxy, the power of attorney, the primary...
Well, hold on. I looked for this healthcare proxy, and as far as I could tell, she was never the healthcare proxy for either of the Dodges. So if that's wrong, Tell me where I'm going to find that differently, because as far as I could tell, it was the sister and the sister, Gail, was the healthcare proxy.
Yes, I believe Gail was the healthcare proxy. Both were power of attorneys, and Ms. Donovan was the primary financial person dealing back and forth. So I believe that Your Honor is correct. She was not the appointed healthcare proxy, but she was still the primary point of contact between the facility and the parents.
And is this intentional infliction or negligent infliction of
I believe it was split both ways, because there was the substantive evidence of harm through her subsequent hospitalizations.
Thank you.
At any point, your time's up, but let me ask this question. For purposes of surviving summary judgment, are you saying the evidence satisfied negligent infliction of emotional distress or intentional? Or are you suggesting it satisfies both?
I believe, I won't try to overstep it, because I believe the court knocked it out on the issue of duty, so it didn't get into which evidence was there. The court said that basically never get into the specific issues.
Right, but our review's de novo, so are you saying that the evidence, which one are you saying the evidence satisfies?
I believe it will satisfy even the negligent, because there is evidence of hospitalization in her affidavit. So there was a substantive evidence of the harm.
So just negligent?
Just negligent would suffice.
So are you telling us that intentional infliction of emotional distress is off the table?
For the purpose of this argument, yes.
Okay.
Make it a simpler conclusion.
Okay. Let me see if there's any further questions from the panel.
No.
Nope. Thank you very much. We appreciate the helpful argument, and we will now hear from another attorney, Joseph Desmond.
Joseph M. Desmond, for the record.
We had, I think, a Joseph D. and a Joseph M. That's so.
The Desmond blood has appellate argument in this.
There we go.
Good morning, Your Honors. May it please the Court, I am Joseph M. Desmond from Morrison Mahoney, representing the appellees Brightview Senior Living LLC and SHP IV Concord River LLC. With me is Lawrence Incata, also from the same firm. We're asking the panel to affirm the well-reasoned decision of the Superior Court on the motion for summary judgment on the counts for negligence, breach of contract, and a mixed bag of emotional distress.
So let's start with my question. You filed your summary judgment motion under Superior Court Rule 9A, or rather you served it initially, correct?
I did.
You filed a 9A package, correct?
I did.
I think the answer to this is no, but I'll ask anyway. The 9A package did not contain any responses to your statement of material fact, correct?
Correct.
Was there a subsequent filing that, from the appellant, which had responses to the joint statement of fact?
To my memory, no, and a quick check of the docket by Ms. Incata when Your Honor asked that question and foreshadowed asking me, we don't find it on the docket. But I don't remember it, and I don't want to misrepresent it to the court, but I don't believe so.
Well, that's very important, right? Because under Superior Court Rule, I think it's 9A B5 3C, the fact, or 3A, I think. The fact that I just said that's ridiculous. But in any event, if there are no responses, they're deemed admitted.
Correct. And we argued waiver in our brief.
So we need to know whether or not that's properly.
I just don't want to overstep and represent to the court definitively where it's that important an issue.
Okay.
My best memory and my belief is that there was no response to the 9AB5 statement. And we argued waiver of that argument because in the trial court, counsel declined to oppose the original motion and argued solely on 56F grounds. And the submission after the fact was at the behest of the trial court judge, and he filed whatever he filed, but I don't think it ever followed the obligation under 9AB5.
But at least as to the argument he submitted, given that it's in response to the judge's specific request for substantive arguments, it does seem that makes the waiver claim more problematic, at least as to the substantive arguments. What do you say about that?
I agree it makes it more complicated. However, without the response, the rules say that the facts are deemed admitted.
Right.
And in fact, there was, and I believe, I don't know if we've submitted, there was another issue in connection with our motion for cost that he refused to order the transcript of the hearing, and I believe there were two, and that shouldn't fall on us, to disprove his accuracy.
So I was confused about the transcript thing, because I wrote the Rule 8, and I wrote the Administrative Office order, and it says that if you file that you want transcripts within 14 days, that the appellant has to pay for it or the appeal is dismissed. So why didn't that happen?
Well, the reply brief addressed, and again, it's a little convoluted and probably off the beaten path from what the thrust of the argument is. But initially, the notice of appeal, the original notice of appeal, also appealed from the courts, from the trial of the 93A. And that's what we were pushing him to order, primarily, because there was a directed verdict on the 93A and the initial notice of appeal, which obviously you would have to have the transcript of the trial and that was the thrust of the argument. When he then withdrew the argument and said, no, I wasn't appealing the trial, you're making it up, it became less important, although it may have some impact on the instruction to follow 9AB5, which wasn't, I don't think, that direct. He was instructed to oppose the motion because there was going to be a substantive ruling.
So when did you ask for the transcript of the summary judgment hearing?
I don't have that in front of me, Your Honor, but it was after the appeal was noticed.
But was within the 14 days that you're required to say you want transcripts, or was it after that?
I believe we had that discussion, but I can't cite the record, Your Honor, about the date, specific date that we requested the transcript.
Did the appellant pay for the trial transcript?
No, the trial transcript was not included in the record, is my belief, because he waived the appeal.
Right, but who,
on the
was it
93A.
created?
I'm sorry?
Was it done? Was it transcribed?
I'd have to double check, Your Honor. I believe that it was, at least portions of it were that we ordered, but when we called off the dogs when he waived the appeal on the trial, it became not relevant. The trial transcript has no bearing on this.
And did you pay for that, or did the appellant pay for it like the rule states?
We paid for it.
Why?
Well, because we wanted we anticipated the appeal and to zealously advocate for our client. We thought
Right, but
we
the
needed the transcript.
administrative order says that you order it, and then the appellant gets the bill and has to pay it, or his appeal is dismissed. Why didn't that happen?
I can't answer that question, Your Honor, without taking a look at it. Was not pursued in light of the fact that he waived the appeal on the trial. It seemed less important as opposed to addressing the substantive issues that he's addressed in his oral argument.
I'm going to ask you the same, changing topics dramatically. Negligence, asking you the same question I asked your brother.
Yes, Your Honor.
Any cases anywhere in the country presenting this assisted living facility negligence, fact pattern, insufficient staffing? It seemed, okay.
No.
That's shocking to me. I mean, assisted living facilities are everywhere. And it seems like people fall and, I don't know, somebody might complain about the lack of staffing, and then the question is, how do you prove that?
They do. And in all the cases that I have, and that's what I focus on is assisted living and long-term care, there's experts.
There's what?
There are experts.
But I mean, okay, so is there a ruling from an appellate court anywhere that you need in a negligence claim alleging insufficient staffing? Yes, even though this is not a medical facility, you need an expert to testify about the staffing levels.
The closest that we have is the Mass Appeals Court ruling in Northeastern versus Goldberg, which is cited and was cited by the trial court, by analogy. And I think to focus so much on the term medical misses the point. The case is whether or not there's professional standards, like architects or engineers or lawyers. Lawyers aren't a medical professional, but you need, because of the professional standard, you need a lawyer to testify as to a breach of the standard of care.
Yeah, I mean, I read your brief and I saw your citation to the regs. That all makes sense to me. I think it's a compelling argument. It's a little bit surprising to me that a court an appellate court somewhere hasn't blessed that with a clear ruling that, yes, in this context, because there's a little bit of ambiguity, because this is not a medical facility, you do need an expert on the staffing, and it would just make our jobs easier if there was precedent. But
I agree, but the case that we cited, I think a close look at that answers the question, because I don't think anyone in this courtroom, unless they've got substantial experience in assisted living, would testify that they're competent to determine the staffing needs, and nor would a jury be competent to say you have enough staff or you don't have enough staff. It's informed by medical professionals. You need to have a physician's clearance form in order to be admitted to an assisted living facility. There are regulatory guidelines and oversight by the Executive Office of Elder Affairs that is responsible for overseeing, surveying, auditing, and determining whether or not
But don't a lot of assisted living facilities have these big disclaimers that say, this is not a medical facility? I mean, arguably, you're trying to have it both ways.
I don't agree. The fact that it's not medical only means, and this is important, I think, to the understanding of why you need an expert to determine whether or not someone is appropriate, whether they've been properly assessed, whether they're appropriate for an assisted living facility as opposed to a medical facility. The regulation in 651 CMR 12.0 is that a person is appropriate when they don't require 24-hour skilled nursing care. And the list of 24-hour skilled nursing care, you then have to go into the Medicaid regulations to see if you qualify clinically for Medicaid in a skilled nursing facility, which is...
So are you suggesting that in any negligence claim against any assisted living facility, invariably expert testimony must be provided, or are you limiting your argument to the facts of this case?
Facts of this case, Your Honor. And there are cases certainly where if someone, and the case law in the Massachusetts Appeals Court is clear, even in a medical facility or a hospital, if someone is required to have a specific care plan in place, like for instance, the medication order says he's supposed to get Coumadin 3 times a day and the hospital is providing it, and they don't provide it. You don't need an expert to say you should have given him Coumadin.
Or if there's a slip and fall at the facility?
Slip and fall case, again, it's not a slip and fall because, again, the question is whether or not the care plan is appropriate. In a care plan case, unless there's a specific care plan directive that the defendant says or the assisted living facility says, we will provide the following specifically to prevent your fall. For instance, a Hoyer lift. Some people need the use of a Hoyer lift to transfer from bed to chair. If the care plan says you need a Hoyer lift to transfer this patient because it's not safe to transfer the patient without the use of the Hoyer lift, and you transfer him by helping him out of bed and he falls, I don't suggest you need an expert. I do think, however, if the allegation was he should have had a Hoyer lift, that's a matter of expert opinion. And so there's a fine difference. And certainly the staffing of an assisted living facility depends on the acuity of the residents. They're not one size fits all. There are memory care units. There are extensive regulations in 651 CMR that speak to the training and qualifications of people who serve in different roles in terms of who the healthcare coordinator is, who the residential services plan is, that I would venture to guess no one in this courtroom could cite, and certainly you wouldn't expect the jury to know. And ergo, you need to have an expert to explain in the facts of a given case why there is a breach of the standard of care. This is a particular, this case in particular, where was the care plan appropriate, was it not appropriate, was the care plan followed or not, should there have been a different care plan that would have prevented falls, because falls happen. Falls they happen in every long-term care facility across the United States every single day by the thousands. And some of them are the responsibility of the healthcare providers, and some relate to the ability of people to have freedom and a dignified existence in a home-like environment as described in 651 CMR. So I would respectfully suggest that there certainly is a need for expert testimony in the facts of this case. The breach of contract, again, we hear that the appellant doesn't think he needs the parole evidence rule, but so there's a few points. Aging in place is a term, again, in the description of 651 CMR 12.0. It's where it's defined. It's an amorphous term that doesn't mean you can live ad infinitum in an assisted living facility despite deterioration in health, as happens in elderly folks. But there's nothing in the four corners of the contract, and I reject the suggestion of my brother that the consumer guide was part of the contract. It was not. And again, Justice Wood asked, does the answer become part of the contract. It's certainly not part of the contract without getting into the parole evidence rule, and you cannot get there in the absence of fraud or in the absence of ambiguity in the contract. And the contract documents include the contract itself and the disclosure statement.
So I don't want you to take this the wrong way, because I'm not saying it controls anything, but I see at the end of the contract, it says, you agree you've read Exhibits A through G, and I see several of those. Is the AG Consumer Guide one of those A to Gs?
No. That's it. The Consumer Guide is an obligation, and again, in 651, part of an assisted living facility's obligation is to share the Consumer Guide to any prospective resident. It's not part of the contract. It is a guide published by
the Commonwealth, isn't it?
I'm sorry?
Is the Consumer Guide put out by the Commonwealth?
Yes, it is. And it's part of, so questions to ask. Now, you can't, even assuming that the Consumer Guide was part of the contract, which it is not, he's proven that we complied with the contract and that we gave them the Consumer Guide. That's the contractual obligation, is to give them the contract. And they can ask the questions. But in the absence of fraud in the inducement or ambiguity, and the documents that we have are the disclosure statement and the agreement that say specifically in each of those documents that if the resident has a level of need that is beyond that of what we can provide in assisted living, you must supplement with additional care or the contract will be terminated. We have the unilateral right in our sole discretion. It's not ambiguous, and there's no fraud in telling them that we have, and it's their obligation under the law not to have people in assisted living that need skilled nursing or need a higher level of care.
Exhibit G is the arbitration agreement.
Yes.
Do you agree with your brother that wasn't signed and that's why that wasn't,
I
you
do.
never put in for arbitration?
I do.
Okay.
Yep. I'd like to address briefly the Rule 56. There's no abuse of discretion. The Rule 56 argument is essentially presented as an omnibus motion to start discovery over, even though every discovery motion...
Apologize for interrupting, but your time is up. I'll let you finish your sentence,
Sure.
and then
It's
we're going to
essentially
have
an
to move on.
omnibus motion to reconsider every discovery order, though none of those discovery orders are on appeal. The one pending motion was the motion to terminate the 30B6 deposition, which was terminated before the end.
We have Judge Liu's ruling on that.
Yes. Thank you, Your Honors.
Just let me check, make sure there are no further questions. Okay. I'd like to thank both counsel for their presentation. The case is submitted. Calling our final case on the list today, docket 23-1245, Hoffner v. Seagull. Just one moment, please. And I know you're pro se, but I believe it's Attorney Hoffner.
Yes, New York attorney.
You may begin.
Good morning, Your Honors. May it please the court, my name is EILEEN Hoffner. I'm pro se appellant.
I'm going to ask you to hold off one sec. Let's wait till your party sits down. Thank you. Go ahead.
Okay. There are two components to my appeal in my brief. One is based on a contractual obligation, and one is based on an equitable argument. It's my contention that our separation agreement in paragraph 18.1 and 18.2 provides for counsel fees, and then 18.1 provides for counsel fees, and 18.2 provides that in the event of a default, the prevailing party is entitled to attorney fees.
Well, if you send a written notice by certified mail, return receipt requested, and email. Did you do that?
We served him by personal service.
You didn't email him? You didn't mail him?
No, personal service, because he was served with a contempt order in New York when he didn't pay.
So why doesn't this, by its own terms, not apply? It requires double service by its own terms before you can have this 18.2
Well,
apply.
I didn't read it that it was required double service. I thought,
Well, it says, "But written notice by certified mail, return receipt requested, and email."
it said certified mail and
And email.
yes, but Mr. Seagull was on the phone with the court chambers and acknowledged that he hadn't paid, and he had violated, he had defaulted against the judge's order. That was following the personal service. So I believe that the personal service was a much more extraordinary source of notice to him because he was handed the papers directly. So quite frankly, I didn't think that certified mail and email was necessary given the fact that we have an affidavit of service that he was personally served on behalf of himself personally and the corporation. There had been absolutely no mention of a notice obligation throughout until the very end. He never made the motion. They never claimed to have not been noticed properly when this case was still in New York. He never made no mention of not being properly noticed in Massachusetts for the first 2 court appearances in Massachusetts. This only came up at the very end. It was an afterthought.
Well, why would any of those apply before you try to use 18.2?
I'm sorry?
Why would any of those things be necessary before you try to invoke 18.2?
I'm sorry, I don't understand.
I don't understand why it matters, why he has to, those aren't good objections to anything that happens until you want to execute 18.2, and then you have to show that you did the service required in 18.2. Did he not raise it at that point?
But all along, I had been alleging that I was entitled to counsel fees for the collection action in Massachusetts. At no point, knowing that that's where I was claiming to be entitled to the counsel fees, he made no mention of inadequate notice. So it never was raised. Otherwise, let's say he had raised it and the judge had found that in his favor, it wouldn't have proceeded.
I think what you're saying is any deficiency in notice has been waived.
Correct. Thank you. That was more succinct.
I'm not saying that's how we're going to rule.
I understand. I understand.
What I understand your argument to be.
My point is that that never was an issue until we made the actual, we were before Judge Tabbitt.
Yeah, so that's actually begs a question, and I know you want to get to the substance of your argument, but Judge Tabbitt noted that he did not have the entire contract before him. I did not see the entire contract.
No, it was not submitted because nothing else was relevant. I have it here if you'd like.
Well, it's either in the record or it's not.
Okay.
But I have a few. Is there? We don't know if there's an integration clause. We don't know if there's any other provisions of the contract that reference attorney's fees.
There are none.
We also don't know what jurisdiction's law controls.
There are no other provisions that deal with attorney's fees. It was governed by New York law, except, but, I'm sorry.
It would have been helpful for the judge to have that before. It would be helpful for us to have that before us, but
In hindsight,
be that as it may.
In hindsight, I would tend to agree with you, but at the time, it didn't seem like it was a necessary ingredient. So perhaps it was an oversight, but as an attorney, I don't think Mr. Seagull would deny it. There are no other clauses in the contract that would have any effect on your decisions.
So 18.2 of the settlement separation agreement says, in the event either party defaults in the performance of any of the provisions of this agreement, goes on.
Correct.
So I'm assuming, if I asked you to identify with specificity the precise provision of the agreement that he defaulted on here, it was the performance of, you would say, 18.1.
Correct, because if that provision allowing me to make a request to Judge Conway for attorney's fees, I had that right in any case. So the inclusion in the agreement could only mean that it was part of the agreement.
I don't, see, that's the problem we have. This is page 37 of the agreement, and I assume there's 36 pages of requirements for the husband to do, any of which would make sense with 18.2. If he failed to do any of those, this would apply. But we don't know what those are, do we? I mean, why does it have to be 18.1? Why can't it be this about if he fails to do Article 16 or Article 13 or Article 12.1?
No, it was for any of the provisions that are contained in the agreement. My argument is this was clearly a provision of the agreement. It had its own category, article, I forgot what article it was, but then it was consecutive. It was not excluded in any manner, so it should be governed by the four corners of the contract. Like I said, the prior article, then this article, and following. There was nothing that took it outside the realm of the contract as it was. Without that provision, I could have applied for attorney's fees and not been benefited by the prevailing party provision.
Yeah, you've said that a couple times. I mean, when I read 18.1, it, to me at least, doesn't speak to any performance by Mr. Seagull. It speaks to, it's not even a requirement of you, it's just the parties agree that the wife may submit a request for counsel fees. That, to me, is no performance obligation at all for Mr. Seagull.
Well, my position is that it's similar to a commercial contract where you have a purchase agreement and you say the parties agree to purchase 100 widgets to be determined by the market value at the time of the contract. Then the purchase price is then subsumed into the contract. It's not excluded. It becomes a part of the contract. So my position is that once Judge Conway affixed a definite amount to the legal fees, that became part of the contract. I don't see how it's any my opinion is I don't see how it's distinguishable. And had Judge Conway said, had we established a set number for counsel fees, that would have been governed by 18.2. So there was a clear intent of the parties at the time, I should speak for myself, that in the event of any default, because that I would be reimbursed for counsel fees in collecting. There had been a long history of contempt. We'd filed a few contempt motions. They were dropped once we got into court. This contempt motion, unfortunately, relating to the counsel fees, was brought and adjourned by the New York Supreme Court until December, at which time I had already been paid, and I had already expended a significant amount of money in Massachusetts to get that. I also want to note that at the very beginning of this suit, maybe within a month, Mr. Seagull offered to pay me $65,000 out of the $85,000 without ever mentioning that he wasn't obligated, or that he wasn't noticed, or any of the objections that then came down later. Secondarily, if he had the $65,000 to pay me to settle it, which was really egregious, I think, because he was supposed to pay me 85. So he decided, well, I'll pay her only 65 out of the court's award. But be that as it may, the fact that he was going to pay $65,000 doesn't suggest that he's not obligated under the contract. It suggests that he, like I, believed that that prevailing party provision was in effect as it pertained.
I don't get that. He knew he had to pay $85,000 because there was a court order that said it, and a judgment. Why does his willingness to pay part of that show that he thinks that you're entitled to
You're correct.
attorney's fees under
But
2.2?
at the same time, within that very short window, we had been discussing attorney fees as well. And at some point, he offered, I don't know, when the attorney fees were $30,000, he offered to give me $2,000 without ever saying anything regarding provision 18.2 or the notice.
So I think, well, you don't have much time. I just want to address.
I wanted to get to, oh, I'm sorry.
Well, the equitable
Yes.
relief. General Law, Chapter 231, Section 6F. You quoted, it's your first argument. Mr. Seagull makes the point in his brief that you're raising this for the first time here.
I'm not.
Okay, can you just give me a record citation? I went back and looked at Judge Tabit's ruling, and he never cites this provision as far as I can tell.
That's the basis of my appeal, that he had this. We argued all along.
Right,
that-
and can you give me a record citation to where you argued that to him?
To him, I don't have it offhand, but
Submit a 16L letter where if you raised it below, and the way we find out is if it's in the record that was presented to Judge Tabit.
I don't believe that I cited the statute, but all along, the equitable argument was raised.
Okay, so you're saying that by making the equitable argument, you implicitly raised this statute?
Correct.
Okay.
There was no, I concede there was, may not have been any direct reference to 231 Section 6F, but the equitable argument pervades the paperwork, the
Thank you.
paper submitted. And clearly, he never addressed the equitable argument at all. And I'd like to add also that when he first ruled against this, he didn't have the benefit of my attorney's invoices, and 3/4 of his decision stated that he couldn't make a decision because there were no invoices and whatever. And then when we pointed it out to him that it was a court error, that the document was incomplete when it went to his desk, the motion for reconsideration said that it was unimportant. But he didn't really discuss anything or make his ruling based on much of anything other than the fact that I had submitted papers without the benefit of my counsel's daily record.
Understood. And your time is up, but I have one final question. Did you draft this brief with the assistance of counsel, or did you draft it?
Myself.
You're seeking attorney fees on appeal.
Yes.
Do we have authority to award attorney's fees?
Yes, I cited the section.
Do we have, when it wasn't drafted by, when you didn't hire counsel to draft it?
Oh, I believe I read that it does not have to be.
Okay.
I'm quite certain of that.
Very good. Let me see if there's any further questions from the panel. Seeing none, thank you very much. We appreciate your arguments.
I'm sorry, it wasn't for attorney's fees, it was for my expenses.
Actually, what you say, it is further requested that this court hold that defendant is required to pay to plaintiff the reasonable attorney's fees and costs associated with the instant appeal.
Okay, I mean, I would
But
wait.
I understand your argument. Your time's up, so we do go by the clock. So
Okay.
thank you so much.
Thank you.
And we will now hear from Attorney Seagull pro se.
Thank you, Judge. May it please the court, Stephen Seagull. I just want to touch on a couple of factual inaccuracy. I never offered $65,000. I didn't have it. That was the problem. By the time we discussed legal fees, it was at the end of an 8-year divorce. The divorce firm billed and were paid $250,000, and I would not agree, it was a deal breaker, that I would not put a provision into our agreement that I'm going to pay her X dollars legal fees. That's how the language came out, in which it said that appellant may choose to ask the court for legal fees. It was my feeling that $250,000 without a deposition, without a custody, without a hearing, without a trial, no judge, in my view, would consider that to be reasonable. So I did not, it was the last and the only thing I wouldn't agree to is a provision in the agreement for payment of legal fees. Number two, so I couldn't have offered $65,000 because all I had was a down payment on a car and a retirement account.
So all of this is in your brief, and
It is.
we've read it. So I think Justice Ditkoff has a question for you.
Can I just add one other factual inconsistency? I'm sorry.
I think you should answer Justice Ditkoff. Let him ask the question first, and
May
then
I?
you can revert
Oh,
back.
go right ahead.
So at one point, Mr. Pearl says that you offered $20,000, and I didn't see anyone saying that wasn't so. Is that not so?
In all sincerity, I have no memory of offering $20,000 or any money to settle it. It's a lot of money, $33,000, and COVID ended my practice. I am a trial attorney. I'm a med-mal trial attorney. And for 2 years, 1 year I made $6,000, 1 year I made $7,000. I only get paid if I win or settle. I now owe $1.2 million. So I don't believe I offered 20, but if I, 20,000.
Actually, I misread it, 20 less, so that would have been about $65,000. So Mr. Seagull actually, attempted to sell for substantially less than the judgment amount, about $20,000 less. And I didn't see anyone correcting that. You represent Mr. Hutchinson then, I think? Or is that someone, am I
I don't
confusing
understand
it?
the question. I apologize.
So at this hearing, in front of the first judge, it said that you offered $20,000 less than the judgment, about $65,000. And no one said that's not true. So
You know,
why wouldn't we take that as true?
I wouldn't take it as true because I didn't have it, but it does make sense when you calculate it. Factually, I just want to point out that there was a contempt of court. Let me get it right. They did make the motion. That was not within the four corners of the agreement. And they were awarded half of $250,000 that I had to pay.
Okay, so let's get to the substance of the argument here.
Yes, sir.
Section 18.2 of the agreement says, in the event either party defaults in the performance of any provisions of this agreement, said default is not remedied, etc., a legal proceeding shall be instituted, and the party shall pay to the successful party the necessary and reasonable attorney's fees in connection with such proceedings. 18.1 authorizes either party to, actually it says,
Just the wife.
the parties agree that the wife may submit a request for counsel fees by notice of motion to the Honorable Joseph Conway. If 18.1 can be read in the manner that you suggest, isn't it effectively a nullity? In other words, if 18.1 isn't included within the meaning of 18.2, then you could just simply ignore it, and while she can institute proceedings to have you comply with the default or remedy the default, she's out of money if she has an attorney do the work for her. I mean, it almost renders 18.1 superfluous in this particular context. That's a long question. Do you understand what I'm asking?
I do. 18.1 speaks to the cost and the reimbursement of legal fees for the cost of the whole divorce proceeding. It has nothing to do with a Massachusetts litigation. Payment to appellant for her legal fees here in Massachusetts, in which they're looking for $33,000. What had happened was when the contempt of court was made, it was settled for $7,000 and it never went anywhere. But in response to appellant's request for legal fees and holding me in contempt, I showed the judge that my mother had given me two-family.
Yeah, the property in Lawrence.
I would sell it. I thought that would satisfy and I wouldn't be thrown in jail. So when appellant learned that I was seeking to sell and pay her, she, in my view, got nervous and hired a lawyer up here in Massachusetts to stop the sale. The TRO was denied. The attachment was granted. And I agreed with every one of these equitable.
I think we were familiar with the facts. I think your point, if I could summarize it very quickly, is you were just proceeding to satisfy the judgment or the amount you owed, and you were in the process of selling this property, and you're saying, I don't know why she needed a lawyer to get an attachment and then much less $33,000 in legal fees. I'm just trying to comply. But you're saying you inferred that she did this because she didn't trust you.
Right.
And maybe who knows if that's good or bad, I don't know. But your point is you were just trying to comply with the judgment. And so now these legal fees, to make sure you comply with the judgment, are unreasonable no matter what else, because you hadn't done anything to warrant the belief that you weren't going to satisfy this prior judgment. Is that your argument in a nutshell?
It is, but I want to add that I agreed to every relief that was asked here in Massachusetts.
Right.
The attachment, the TRO. I wasn't fighting it. I even allowed it to go forward to a judgment. I was not going to stop.
Right, and ultimately you paid, you sold the house and paid the $88,000, whatever, the amount plus interest. That's the bottom line. You
And
did
in
it.
escrow is the $33,000.
Right.
I want to point out just a couple of things real quick, unless I have 6 minutes. The motion that was speaking here, in which Judge Talbot, did he?
Thabit.
I think Thabit. Okay. The motion, original motion, that brings us here today, cites the wrong statute for recovery of the money. It cites Mass R Civil Procedure, the P69 and GL Chapter 223 at 86A. The correct legal fee section in Superior Court is 9D, Rule 9D. So the first thing is that Judge Thabit was ruling based on the four corners of these two statutes, and they were the incorrect statutes. In addition, on appeal, they cite the wrong statute as well. They cite no, it's the right section, GLC 231, 6F. but clearly it says that it's based on what I had put on the record before. So,
let's go back to the contract.
okay.
Tell me with great specificity
Okay.
why, because here we have a default entered by the New York judge,
Yes,
which, in order to satisfy that default, you had to sell property in Massachusetts. So tell me why in this context, 18.2 does not modify or apply to 18.1.
okay. Just give me one moment.
Why did what happened here not constitute a default in the performance of Section 18.1 of this agreement?
18.2 speaks to defaults in the performance of the provisions of this agreement and nothing else. I did not default in this agreement.
Did you default in 18.1 by failing to comply with the counsel fees awarded under 18.1?
$18.1 does not speak to my obligation to pay legal fees. In fact, it was my insistence that no legal fees be cited here and that an application can be made at any time. So 18.1 does not obligate me in any way to pay any legal fees. 18.2 speaks to...
Unless the judge awards it.
Yeah, yes. No judge ruled that I had to pay. Well, we're talking about the agreement. The judge did order me to pay. I didn't have the money, so I was selling a house. It took time, but it got sold. She immediately got paid at closing, and my obligation had been satisfied, albeit late, but satisfied. 18.1 talks about the wife having the right to ask for legal fees for the divorce, for the entire process. It's common that there is fee shifting, and the term is to make it a level playing field so that one party doesn't have more money than the other and can get a better lawyer than the other. So during the pendency of the proceedings, this is 18.1, spoke to the entire 8-year divorce and the legal fees that were generated there. It didn't speak to any other action, default, or anything like that. And in fact, if you look at 18.2, there was no application. There was no, there's a certain requirement of written notice. I got no notice. I don't think it would have made a difference because I didn't have the money. I had a car and I had a retirement account. I needed to sell that house. Today, I own nothing. 39 years as a lawyer, I do not own a thing. This divorce and COVID ended my practice. I'm closing. I've enjoyed it, but I just can't sustain it.
Okay. Let me see if there's any further questions. Seeing none, thank you for your argument. Thank you both for your argument. We will take this case under advisement. The case is submitted, and that concludes our session.
Thank you, Judge.